First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, great state of Florida, and this honorable court.
Please be seated. Okay, good afternoon. Welcome to the First District Court of Appeal. We're happy to have both parties present here today. We apologize for the oversight again for Apalachicola, but glad we have everybody noticed in here today. Our one case is Ray versus Ray, which is 223798. Counsel, are you ready to proceed?
Yes, Your Honor.
Please proceed. Good. And Mr. Williams, before you get started, would you like to reserve some time for rebuttal?
Yes, sir. I'd ask for 12 and 3 minutes for rebuttal.
3 minutes for rebuttal. So noted. Thank you.
Thank you, Your Honor. May it please the court, my name is John O. Williams. I represent the husband. The husband requests that you correct the trial court's erroneous determination regarding marital and non-marital property. The most significant errors regarding certain real property in Liberty County that was consistently referred to at trial as the 320 acres, which is actually a half a section of land in Liberty County, Section 18, Township 2, South, Range 5 West. That parcel was used by the marriage for personal use, for business purpose, a recreational business, mostly hunting, and for marital timber business. The wife ultimately received the land, the timber that remains on the land that has a substantial value of $176,000, and the $400,000 she received from timbering the 320 acres that she received at or about the time of the separation in May of 2015. The amended final judgment of dissolution of marriage also lacks independent judgment by the trial court, is unfair, and should be reversed. The trial court determined that the 320 acres was non-marital because it was inherited by the wife. There was not any competent or substantial evidence to support such a determination.
Weren't there deeds to support that determination that were deeded solely to her, including one deed for 160 acres that was even before the marriage?
Yes, sir. What the deed situation was that there were two deeds before the marriage, a 1979 and a 1980 deed. And both of them purported to provide to her a undivided 1/4 section of Section 18. And then in 1992, the grantor, one of the grantors of the first, re-granted the entire property, which was the wife's grandmother, to the wife's mother. And in 1995, the wife's mother granted the whole section, all 640 acres, to the wife. The deed the court relied on was a 2009 deed. And the 2009 deed was a result of 4 years of litigation between the brother, the wife's brother, and the wife. And I believed in there, one of the points we were making is that there was consideration because prior to that time, the marriage had placed $100,000 into the property for trees, for planting trees. There were some roads built in there. There were some pole barns built in there.
That $100,000, though, wasn't that credited? Each party was assessed $50,000 or awarded $50,000 in marital property from that $100,000.
No, what the court did on that, Your Honor, was they said, well, whatever you increase the value, and the appraiser said it increased the value, whatever that was, and they split that. They didn't say that. But my point is that the money, that there was money already invested in the property. Then in 2009, after there was litigation between the brother and the sister, the husband signed a settlement agreement in that. The husband also signed a quitclaim deed to 1/2 of the 640 acres. The 640 acres the marriage didn't receive. So from my standpoint, we had a deed during the marriage which should have given us a presumption that it was marital property.
But it was a deed. The only deed that the husband was involved in was a quitclaim deed conveying I would assume like a regular quitclaim deed, not guaranteeing any interest, but saying if I got any interest in this, I'm giving it away, right? So
Correct. And he also signed the settlement agreement, and also there were terms in the settlement that the marriage paid. For instance, they had to survey the property and get a 10-foot right-of-way. There was approximately $17,000 in attorney's fees that were paid, and they paid the mediator fees. So there was work involved in that the marriage paid. So the marriage had invested in the property, they litigated for the property, and then they paid whatever the settlement fees to obtain that particular piece of property.
But the original question to you by Judge Bilbrey was, with respect to your statement that there was incompetent substantial evidence to support the idea that the land was originally inherited by the wife.
I don't think it was inherited, Your Honor, because...
Well, you just mentioned the deed, you yourself mentioned the deed that transferred the property from the mother to the wife.
But it wasn't an inheritance, it was a deed.
Okay, but it was transferred. I mean, the statute doesn't require that it be inherited. It can be transferred as a gift as well.
That's correct.
And so there was evidence in the record that showed that it was transferred to the wife from the mother. Is that
That's correct.
Okay,
But
so
what
then the statement that there's not CSE to support that is not accurate, right?
No, what I said is that the deed didn't support inheritance. I didn't say it a gift. My argument with regard to the gift was when we were back for a rehearing, the judge said from the bench that, well, this must be a gift. It didn't get into the amended final judgment. So there's nothing in the amended final judgment that says it was a gift. It says it was inherited.
So would you like us to remand and direct the trial court to say gift instead of inheritance, but change nothing else? I mean, that doesn't benefit your client any. Whether it's a gift or an inheritance, it's non-marital, right?
Correct, Your Honor. What I'm suggesting is that there was a deed during the marriage for which there was substantial consideration. So with that deed, that became marital property.
The consideration that you're speaking of is the attorney's fees that were paid with regard to the litigation concerning the property?
I think that, Your Honor, and I don't know which deed this court would want to rely on. One of the arguments is that during the marriage, this was a situation where my client was older and he had some money and the wife did not. The parents needed some help, and that's when I suggest you the 1992 and the 1995 deed. What I'm suggesting is that what the marriage was doing was helping support the parents. Usually it's the other way around. But they were on a restricted income, and so there was these transactions in which the wife's mother deeded the entire 640 acres to the wife, and then the husband and wife put $100,000 in that, and they were using that for income, and part of that income was being used for the parents. So what I was suggesting in that argument is that whether it's the 1995 deed or the 2009 deed, there was substantial consideration paid by the marriage before any of this property was actually conveyed. The other thing that I was suggesting with regard to the 320 acres is the same facts which show that there was a marital gift. And I know, at least from this court in Hooker versus Hooker, said, well, that has to do with evidence and this is a tight factual situation. But from a public policy standpoint, if what we're going to do is give marriage a special place, one of the things in a long-term marriage should be is that you should at least be making it clear to your spouse what's going on. And part of the evidence is the husband testified that she told him that it was going to be their property. It was going to be used for their retirement. She never refuted that. There was no refuting, said, no, I didn't say it. There was nothing to the contrary.
So that's some sort of equitable argument then. Did you need to plead a constructive trust to be able to raise any of these kind of equitable arguments?
The judge ruled as far as constructive trust, and I think he ruled that I don't know why I would have had to plead a marital gift. I don't think you have to plead that, but I would have had to plead constructive trust. But I asked the court to conform the pleadings to the evidence, which I think should have been granted. There was no objection to any of the evidence that was put in the record, none. And so the same facts that support my idea that there was a deed during the marriage also support the theory of gift of the marriage, which I think Hooker versus Hooker talks about that, and all the things that the marriage was doing for this property. This was something that they both worked in from the time that they took any real interest in, which was 1995, and they were growing timber. They planted timber. They did a lot of things to the property so that they could use the property for their marital businesses.
But am I not correct that under item 15 on the Exhibit A, the wife was assessed $50,000 on her side for the enhancement of value, that she, from the $100,000, she had to take 50, right, of the marital assets that were used for the benefit of the property?
I think that's what the court ruled.
Can I direct you, before we go through all your time, to your first issue on the claim that there's lack of independent judgment by the trial court? I went through the transcript of the hearing on the motion for reconsideration that the judge, granted reconsideration and had a full hearing. Where does that show a lack of independent judgment? It looks like he was getting pretty into the weeds with both counsel on what asset goes where and who gets what. How does that, shouldn't we consider that in determining that there was independent judgment?
I think so, Your Honor. My problem was nothing was really changed, and he didn't address my arguments, and I don't think that's fair. I don't think he really addressed my arguments in the amended final judgment. I think the judgment went in, it was adopted word for word. There were only, even with the typographical errors, then when I pointed out the typographical errors, they corrected that, and there were a couple of very minor errors. Other than that, the judge talked about it from the bench, did not amend the final judgment at all, and it wasn't, other than those couple of things.
Go ahead. I was just going to say, just because he didn't agree with you doesn't mean he lacked independent judgment, right?
I understand, Your Honor, but it seems to me it should have been pointed out in the amended final judgment, because these were discussions from the bench, and he ruled against it. But where in there does it, for instance, they never addressed the $400,000 that was taken in 2015. He didn't address at all the value of the remaining timber on the land he gave, which is $176,000.
But your point is, your first point is look, he took the proposed judgment almost as is with a couple of corrections. And I'm wondering how do we apply, what legal standard would we apply? Like, how many changes would he have to make for it to not be offensive to you?
Your Honor, I think that he should have addressed my arguments. I put them in a proposed order. What happened is the judge asked for a proposed order for both of us and tried to come up with one. So we did one back and forth, and the judge found that confusing. So he said, okay, both of you send one in. So we both did. Okay. And then one of the things I put forth in my motions is, please address these issues, because I wanted them to be crystal clear for the appellate court if we decided to appeal. And I don't think they were.
Or did you object? Did you
sorry.
object to the whole process of submitting a proposed judgment? It seems like if there's going to be a legal issue that you're going to make on that subject, it would be, I don't think that a judge should invite a proposed judgment. If the judge is going to be exercising equity, then he should actually write his own order. And you don't object to that. You submitted your own proposed order. You went along with the whole process, and it sounds like what you're really unhappy with is that he adopted the other side's proposed order.
Well, I don't like that, but that isn't what I'm objecting. What I'm objecting to is that he didn't address the specific issues I asked him to address. And then even after the second one, I made some suggestions because I didn't think they were being addressed. Well, he denied that. So he didn't address in the amended final judgment some very specific things in there. And my problem with the order overall, and the lack of independent judgment, We said that there was over $3 million worth of assets. They said there was 2.2. He adopted their numbers by the penny. Now, Your Honor, all this was on estimates, basic estimates. It's hard to understand.
Did
why
you
would
propose
adopt-
hard numbers?
Excuse me?
Did you propose hard numbers in your proposed judgment?
Yes, I did.
Okay, so what's the difference? It's just, so you're suggesting that your numbers would be okay, that would be independent judgment, but because he adopted the other side's numbers, that it's not independent judgment?
What I'm suggesting is that every single value was adopted from the white. He didn't give, so any witness I put on had zero credibility. So at least the judge should say, you didn't even put on one witness that had any credibility. But when you adopt when you adopt something dollar for dollar, at the very least, it doesn't look good. And particularly when these are estimates of value.
And counsel, we burned through your rebuttal time, but we'll give you 3 minutes more if you wanted to
Thank
reserve
you,
that.
Your Honor. I appreciate it. Thank you very much.
So we'd add 3 minutes to the rebuttal time, and we'll give Mr. Roberts 3 minutes more for his argument if you need it.
Good afternoon. I do want to address the first point that was raised that you questioned about judgeability is whether or not the trial court engaged in independent decision-making authority. And just a simple review of the transcript from the hearing on the husband's motion for reconsideration, I'd like to point out what the judge said, and I'm citing to the transcript. The judge said, I take, copious notes, very precise notes, and then afterwards we get proposed orders. Sometimes I get proposed orders that not only are conflicting in terms of what one party thinks happened at the hearing versus the other, but sometimes I can tell that there were things in there that weren't even addressed at the hearing. And I'm not saying that that happened in this case, but I guess what I am saying is that when I got to the proposed orders, they seemed to be so different, it was hard to imagine that everybody was in the same hearing. They were that much different. They were so different from each other, and I finally sat down and plowed through the stuff and issued an order. So he addressed that. It's clear that he put a lot of attention into the proposed final judgments that were submitted. And I agree with counsel that he's talking about credibility of witnesses, and the trial judge should be given great deference when he's sitting there personally viewing and observing them. And he did comment in the motion for hearing concerning the husband's credibility. And I'm citing to the transcript from the motion for hearing when we were discussing the husband's claim that his daddy had given him $300,000 that he had just put in a box. And the court said, yeah, I remember this too. So in addition, if you're taking notes for order on this hearing, Mr. Roberts, yes, I agree it should have been pled, but also this was not just weight of testimony. It was also credibility that came into play pretty heavily here. So my ruling on the effect of that evidence stands. So it's clear from just a reading of the transcript that the trial court judge engaged in independent thinking.
Do you dispute the fact, though, that the judge pretty much adopted verbatim the order that you proposed? I don't mean that pejoratively, just there's a significant similarity between them.
I believe that he did, and I believe he has the authority to do that. And I believe it was the Dorman case that I cited. He asked for proposed final judgments. Nobody objected to that.
Sure.
We both submitted those proposed final judgments. He took 26 days to review those final judgments before he issued a ruling.
Well, you don't know that he took 26 days to review it. You just know that it took 26 days before it came out, right?
Correct. But on the case that was cited by the husband's counsel, Bert Perlow, it was completely different. The court adopted a 26-page final judgment 2 hours after the conclusion of the hearing when the court didn't even request proposed final judgments from either party. He cited that as one of the reasons why the court should be reversed on that issue. But I think the facts in this case are different based on both parties being requested by the court to submit proposed final judgments, both nobody objecting to that, and then the court not ruling immediately, but almost a month later. So
yeah, but on that, it seems like the only way to it seems problematic in a way. I mean, you have a trial court that's engaged in pure equity. This is all equity. So it's essentially like a chancellor sitting there hearing all the evidence and making equitable decisions. And it seems a little bit inconsistent, though, than to after all the evidence comes in, to have the lawyers do all the work for the judge who's going to be doing equity. And it seems at that point, though, it's either an objection to the process entirely, that the judge should not be asking for proposed orders, or not. And not this sort of, well, I'm going to propose my own order, and the other side will propose an order, and if I don't get my proposal, then I'm going to complain that it wasn't independent judgment. You can't play along with the process and then object to it. But applying sort of these factors, though, doesn't that invite an appellate court almost to be doing some fact-finding?
I believe it does, but if you look at the differences in the proposed orders and what the court's findings were, the court even addressed which witness he gave more credibility to. For example, when dealing with some of the property, we retained an expert certified appraiser to do appraisals and to come to court and testify, and he'd been qualified as an expert many times. He had prepared thousands of appraisals. It was stipulated that he was an expert. And then the husband didn't hire an expert. He had a realtor come in that had provided no prior court testimony as far as expert, and the realtor's value exceeded the appraiser's value by almost double. And so when asked about the various approaches to valuation, the husband's witness, the realtor, was not able to tell just the basic, the general principles as far as valuation of real property. So the fact that the judge went along with our expert, Gus Burt's figure, versus going along with the husband's witness's figure, I think is supported by the evidence.
What about, so it looks like the proposed orders, both sides, are in the record, but in the record is notice of filings after everything happened, almost like as a sort of before the gates close and the thing comes up here. They get those proposed orders in, and there's no like foundation. What are they? Is that a proper way to make a record on that issue?
There was a stipulation by the attorneys. We wanted to get through with this final hearing. This case has been pending for our clients for over 3 years from the date of filing. We had an all-day trial set, and it was getting close to, we knew we were going to finish, and to try to get it reset and have the judge try to recall everything from months prior at a separate hearing. We just stipulated to the entry of a lot of these exhibits.
No, I mean the proposed orders themselves. The only way that I think that we know what the proposed judgments on both sides are is because the appellant did a notice of filing with both proposed judgments after the fact, like after the judgment, after the rehearing, and everything else. Is that with no indication of whether those things were actually submitted to the trial judge at the time? Is that a proper way to preserve the record, or is that another argument for a waiver?
I don't think it's a proper way to preserve the record, but we did do stipulations. For example, we stipulated to file the wife's 2015 and 16 tax returns after the fact, which we did, which shows she received no substantial income from thinning timber, as claimed by the husband. And the husband has all these theories and stories that he argued, but dealing with 320 acres is what John spent most of his time on, so I do want to address it. It was clear that the 320 acres that the wife received from her family, none of the husband was never placed on any of the deeds. And even though he signed a quitclaim deed during litigation, which is common, which Judge Frank referred to, he never demanded that the wife put him on any of those deeds. In fact, the arguments that he made is that he helped the wife's family financially, and he just assumed or anticipated that some of this property was going to put in his name, was not supporting anything other than the husband's self-serving testimony. The wife denied that, so there's a conflict in evidence with that. As you addressed earlier, a fourth of this property came into the wife in 1980, 10 years prior to the party's marriage. All the deeds, the doc stamps on the deeds reflect very nominal payment, which shows more of a gift intent from family. As I said, there was no dispute the property is never placed in the husband's name. There's no dispute that the parties never took out a mortgage during this marriage on any of their property. And so the trial court was tasked with the decision, did the marriage on the property, and if not, what was the value of the marital component? And we stipulated there was a marital component, and that's why we had the expert come in and testify about what the improvements were made during the marriage with marital funds or labor and how much that enhanced the value. And the court went through those findings, and he found that it enhanced the value of the property, and that he assigned that enhancement of the value to my client in the equitable distribution scheme.
But before we even get into the facts of that, was that something that needed to be pleaded in a counter petition, the constructive trust or some interest in that property?
Yes, sir. Claims of special interest must be pled. Failing to do so, the court lacked authority to grant them. And that's cited in Dorman v. Dorman. That's the first DCA case from 1976. And this case was similar to Dorman. The husband, he didn't even file a counter petition. The husband, at any time there's 3-year litigation, no counter petition was filed. He filed a motion to conform the pleadings after the fact, which I believe the trial court appropriately rejected. The husband does not complain about that on appeal, so I believe he's waived that. And the theories of constructive trust, I don't believe they were tried by consent. And if you look at the transcript, there's not one place in the transcript where the word gift or trust appears. It's just a legal theory that was raised by opposing counsel during his proposed final judgment. But if you do a word search of that transcript and try to find trust or gift, you're not going to find any, with the exception, I think there's one place that John made it in an argument, but it wasn't testimony from either of the parties. So it wasn't pled, so I don't believe the court even had the ability to consider that, because there's nowhere in the pleadings, and I think Dorman precludes it. He makes an argument concerning value for the wife that allegedly timbered the property in 2015 or 2016. And then he makes claims of dissipation in his brief, but that was also not pled. And then he wants to argue what was the actual date of filing, because there was a filing earlier in Liberty County in 2015, which was abandoned. The husband objected to venue and moved to dismiss for that. So we were traveling under the 2019 filing, and that's what the court found, and the court went by the statute. It's the petition, not any petition. So I think the judge was correct in using the filing date in this pending action here in 2019. The tax returns, as I said, which were supplemented on the record, did not show that the wife received $400-some thousand in timbering. The husband produced no receipts, didn't call any witnesses, any loggers, or anything to establish this value that he's picking out of thin air, that $435,000 that my client supposedly received from timbering the property in 2015 or 16. The only testimony or evidence comes from the husband, which was self-serving.
Well, if this was her separate property, does it matter? I mean, she could have received $10 million for it. If it's separate property, it's hers, right?
Yes, sir. It goes to my next argument when he claims that the court committed reversible error by not valuing the timber separately on the wife's non-marital property. And my expert was questioned about this, Mr. Burton. He said, I just value the property as a whole. And the husband, he came up with this value of $435,000. He said that they had fenced some property on a different piece of property about a year prior to that and got approximately $1,500 an acre. And he took that and times by acreage and said this is what the court should attribute that the wife misappropriated or intentionally wasted. But he proved no misconduct on behalf of Mrs. Ray. And Mrs. Ray said that I did some timbering. I don't remember how much I got, but I know I put the majority of it back into my non-marital property, was the argument. So a lot of the things that opposing counsel wanted the court to make findings of as far as assets that were simply not there, like $435,000 or dissipation from timbering, which wasn't proven at all during the trial court. I believe the court would be tasked with an impossible task in even addressing those theories that were made after the close of the evidence.
Did I hear you suggest that a party's testimony doesn't constitute competent evidence?
No,
because it's, quote, self-serving?
Testimony is evidence. However,
isn't every party's testimony self-serving?
To a certain extent, yes, sir, it is. We had a judge from Jackson County that said divorces are decided by the preponderance of the perjury. So I agree that everybody's testimony is self-serving to some extent in a divorce case.
So if the husband were the only one testifying, and I'm not saying he is, but I'm not sure what you're suggesting by, he testified to something, but that was self-serving, so that's not good enough?
Well, a lot of the things the husband testified to were contradicted by the wife's testimony.
Sure.
And so basically, the judge had to make a decision on who he believed was more credible.
Okay.
And he did address that based on some of the husband's claims. If you look at the husband's deposition testimony versus the husband's trial testimony, there were several inconsistencies there that were pointed out. And so I believe the husband was impeached several times during the trial proceeding concerning his prior inconsistent statements and his positions concerning money that he allegedly received from his father, what he did with that money over the years that he had it before he allegedly spent it on this property in Montana. He claimed that the original down payment came from timbering from his non-marital property, and later testified it came from the party's marital property. And so it was all over the place concerning his inconsistent statements. And so I kind of agreed with Judge Frank when he wrote in here. He wanted to know if we were in the same room, the same hearing, based on the vast differences in the submission of the proposed final judgments.
But even if the husband weren't impeached at all, I mean, if it's just straight testimony, there's some cross, but there's no like impeachment, isn't the trial judge free to still discount or ignore that testimony just by observing the testimony? I just don't believe him.
Absolutely. The judge has that right and authority. And I think he should do that, because if you look at what the husband was claiming, referring to the cash that he claimed that he took out to Montana and paid the builder, he didn't call the builder as a witness. He didn't submit any receipts from the builder. And in other places, he testified in his deposition that that money was put into an account, and when the builder called for a draw, it was a marital account, that's where the money would come out of. And so for the husband to argue on appeal and be upset that the court didn't find his testimony credible about the $300,000 that he supposedly was gifted by his father, and it's interesting to note that at this time this alleged gift was made, the husband's mother was still alive and he had other siblings. And the husband's father was an electrician, and the husband, my client, testified that they never had a large amount of cash, and she was unaware of any $300,000 that the husband now claims, when they're going through the divorce, was supposedly gifted to the husband by the father, which he used to build a portion of the proceeds of that for the house in Montana. So I believe that the trial court, when we come into these type proceedings, I know y'all have heard 1,000 times, it's clothed with the presumption of correctness, should give a lot of deference. And I think the judge was charged with a difficult task. I will say it's very easy to work with opposing counsel. We did get through a lot of things, and if you look at the final judgment, there were a lot of stipulations that were made as to values and different things. So there's a few of these issues, but they were big issues that we tasked Judge Frank with having to make a decision. And I don't blame him. I dislike submitting proposed final judgments. I love it when the judge says, I'll give you a ruling or issue a letter of ruling in a little while. But it was difficult to draft this final judgment just based on the circumstances and the testimony and all the exhibits. But I think that the trial court did a good job. When opposing counsel asked for rehearing to address some of these issues, he thoroughly went through each and every one of those, and he made oral findings as to why he was going to grant this or to deny that. And I think that the final judgment should stand, and that the court should not grant any type of appeal.
Thank you, counsel.
Your Honor, one of the things I would request is that if you look at the 320 acres, that how that was determined by the court to be non-marital, then I'd suggest you use the same standard on the Montana property. Montana property was in the husband's sole name. Wife said the marriage had no money that she was aware of. The husband said the money came from his father, and other money came from timbering on land he owned prior to the marriage.
But I mean, isn't there a big difference, though, on how the property is acquired? So if during the course of the marriage, one party goes out and buys something, the presumption is that's marital property. So I go buy a new car, the presumption is it's marital property, and if I were to get divorced, my wife and I would need to equitably divide that. Whereas if my father gave me a car, the presumption would be that it's a gift, right? It's a not, and if it's just titled in my name, I don't put my wife on it. So aren't you saying that the law should be the same on both of these things, but really the law is different?
Well, I think part of the issue, Your Honor, is that this 320 acres, there was 4 years of litigation about it. This wasn't a simple thing. This wasn't a matter I gave it to you. Okay, if you say it's clear that somebody gave it to you, and why and how. But I don't think that's that clear in that 320
But couldn't we draw
acres.
the other inference, though, that after 4 years of litigation, the deeds, any deeds that came down, nothing transferred the title to them jointly. It was only in the wife's name even after all that litigation. So couldn't that swing the other way?
Your Honor, I think in marriages, you want the other spouse to have the property. It's not a matter, and I think that's my point as far as looking at this in the larger context. When you're married, and particularly long-term, if you want to keep things separate, it ought to be clear, and it ought to at least be very clear to your spouse. And that's part of, when you look at the dynamics of this, if you're going to look at these things individually, then I ask, okay, look at the Montana property, and that there was no evidence contrary to what the husband said. And when they talk about, well, you couldn't rely on the husband, almost every number in there was from the husband, other than estimates of the appraisers. But every number, when you bought it, the years they bought it, of every piece of property, the businesses and everything. So the court accepts all of that, except when he says, I inherited money from I didn't inherit, it was gifted to me by my father. And the wife says, yeah, we didn't have any money. If you put money up, it couldn't have been. I guess my time's up here.
Thank you, counsel.
Thank you.
Thank you both. We appreciate the argument, and glad to see both of you up here. Thank you for coming. And with that, court is adjourned.
All rise.
You look like a marshal. Hey, John.